Hello, everyone. Uh, Today we are having
Hello,
a
sir.
conversation about foreign awards, international commercial arbitration, enforcement of these arbitrations. What is the framework in India? How have the courts dealt with this? What should be the future? What are the stumbling blocks that we are facing, and how are we going to eradicate all of this? So in the class, we'll cover these issues. We'll also discuss as to how a good arbitration agreement must read when we are dealing with the situation of foreign arbitral awards. Now, why do we discuss this in the first place? I think it's important to put a context to this. The primary reason we are discussing the issue of foreign arbitral awards or resolving these awards is an issue of resolving disputes. Now, how do these disputes come about? Are these disputes only coming about through trade? Are these disputes only restricted to certain contracts? Who are the parties to these contracts? Are these contracts between governments? Are these contracts between companies? Or are these contracts between governments and companies? Does the regime also include participation of nationals of India or foreign nationals of India? Does this also include transactions which are not commercial in nature? Can we deal with security contracts? Can we deal with contracts on maritime? And therefore, a lot of this framework is designed to deal with this situation. Now, this situation has not come about now. We have been dealing with trade as statal entities for a long time now. And therefore, the 1923 and 1927, and that convention is still on the books today. Now, why did the Geneva Convention come about? The Geneva Convention and the Geneva Protocol did not just come about to resolve commercial disputes. It did not just come about for arbitrations. Geneva Conventions came about just to get some kind of agreement between different states when you're dealing with disputes of any nature, even if you're dealing with disputes of war or maritime issues or normal contracts. A part of that is obviously how you're going to resolve other disputes, which is already there in our Arbitration and Conciliation Act 1996, Chapter 2, Part 2. Now, fast forward some years, we have the Second World War. Many countries become independent. Colonial rule has come to an end. There are many different countries who are going to now trade as sovereign and independent entities. And now the world order needs a more updated convention to deal with different disputes. And that's the framework with which the New York Convention comes about in 1958. That New York Convention is still on our books, Chapter 1, Part 2. So when we are discussing enforcement of foreign awards, we are largely discussing how awards can be enforced under these two conventions, the 1923 and 1927 Geneva Protocol and Geneva Convention, and the 1958 New York Convention, which is overwhelmingly more relevant today. Now, India, in response to both these international conventions, made its own domestic legislation. The Arbitration Protocol and Convention Act of 1937 was a response to the earlier Geneva Protocols, and the Foreign Recognition and Enforcement of Awards Act 1961 was a response to the 1958 New York Protocol. Now, the current Arbitration Act is largely modeled on the UNCITRAL Code that came about in 1996. And there have been substantial amendments to this UNCITRAL model in 1516. And therefore, there have been some momentous amendments that have come about in our legislation in 2015 and 16, whereby some court decisions, marquee court decisions, have been overruled or changed, and the way forward has been straightened out at some places, and we've turned a different corner at certain places. So therefore, let us examine what is the difference between a foreign award and a domestic award. And it is res ipsa loquitur. A domestic award is an award which is based in India. And we'll say a foreign award is an award which is based in a foreign country. But what makes an award foreign? Does it mean that if a foreign party is involved in terms of a foreign government or a foreign company or a foreign national, is that what makes an award a foreign award? And then what's the difference between an international commercial arbitration and a foreign arbitration? Now, in a very broad sense, yes, if an award has to be a foreign award, there has to be an element of the word foreign in it. But the element does not come from persons. The element actually comes from territoriality. If an award has been given in a foreign territory, in our definitions, we consider that award as a foreign award. It doesn't mean that if one of the contracting parties is located in a foreign jurisdiction and such a resolving of dispute between a foreign party and an Indian party would make the award a foreign award. That's not the case. And why do I say that? Because when you look at our law itself, it does not discuss anything about what is a foreign arbitration. But it does go ahead and define what is a foreign award. So I will just screen share so we could look at the arbitration award together, and that would give us a better understanding. Right. Is my screen visible to everyone?
Yes, sir.
So let's look at the Act itself. Now, when we get to the index of the Act, you see the Arbitration and Conciliation Act 1996 is essentially a sum total of 4 parts. The first part generically says arbitration. And therefore, there have been discussions in the Bhatia case and then in the Balco case and separate amendments to say that is part 1 limited only to domestic arbitrations, or is part 1 dealing with both domestic arbitrations as well as international commercial arbitrations. But simply when we look at the Act, part 1 says arbitration. It does not say domestic in that sense. So it's not as simple. Then as we scroll further, part 2 is enforcement of certain foreign awards. And therefore, when we say certain, what does it mean? Why does it use the word certain? Which means that certain awards can be enforced and maybe certain awards cannot be enforced. And that's a hypothesis we'll try to answer in today's session. Part 2 by itself is broken into 2 parts. First is Chapter 1, which deals with New York Convention awards. Chapter 2 is the Geneva Convention awards. Part 3 is conciliation, and part 4 is supplementary provisions. So in today's conversation, we are not discussing part 3 and part 4. Our conversation is largely going to revolve around part 2. And we are going to make a mention of some parts of part 1, and that keeps the hypothesis open whether part 2 and part 1 are mutually exclusive, or does part 2 borrow something from part 1. Now, when we look at the definitional section, which is there in section 2, the definitional section does not define what is a foreign arbitration. But I began by saying that if there has to be a foreign award, it will become a foreign award on the basis of territoriality. Now, how do I come to that conclusion? Let us examine this. Since section 2 does not define what is a foreign award, let's come to section 2. It says arbitration, arbitration agreement, arbitral award, arbitral tribunal, court. It does make a mention of international commercial arbitration here, but if you read further, it doesn't make a mention of what is a foreign arbitration or a foreign award. Now, when we search for this definition, we find this definition in section 44. So let's come to 44 and see what 44 says. Now, 44 is the very first section of part 2. The heading to the section is definition. And what does it define? It defines a foreign award. So let us look at the legislation and see how does the legislation define a foreign award. It says, in this chapter, unless the context otherwise requires, foreign award means an arbitral award on differences between persons arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, made on or after the 11th of October 1960, and then subclause A, in pursuance of an agreement in writing for arbitration to which convention set forth in the first schedule applies, and second, in one of such territories as the central government being satisfied that reciprocal provisions have been made, may by notification in the official gazette declare to be territories to which the said convention applies. Now, the definition is not very simple, so let me explain what I understand from the section definition. The definition can be broken in certain parts, and these are the constituent parts from which we can understand whether an award is a foreign award. Now, like I said, that this section, this part, deals with enforcement of certain foreign awards. So clearly, when we look at the definition in 44, it will talk about foreign awards which are certain. And there are some foreign awards which this does not cover. So let's try to understand what does it cover and what is it not covering. Now, the very first requirement for an award to be a foreign award is that it must be an arbitral award in the first place. And this particular legislation defines what is an arbitral award. And I'll quickly skip to section 2, because in 2(1)(c), there is a definition of an arbitral award. Now, the definition is an inclusive definition which says arbitral award includes an interim award. Therefore, from a very common interpretation, what an arbitral award would include is both a final award and an interim award. And because a foreign award's first requirement is that there has to be an arbitral award, a foreign award can also be an interim award. Okay. Now let's come to 44. What's the second requirement after the requirement that there must be an arbitral award in the first place? The second requirement here is that that award must be on differences between persons arising out of legal relationships, whether contractual or not. Therefore, when we are discussing a dispute, it is not necessary that the dispute arises out of a contract. Now, largely what we understand of arbitrations is that we are dealing with contractual disputes, where there is a contract, in the contract is embedded an arbitration clause, and therefore as lawyers, when we are looking at a particular contract and we have to advise the client whether he can take it to arbitration, the first thing we'll do is scroll through the contract and see whether it has an arbitration agreement. And if that contract has an arbitration agreement, our broad understanding is that we are not going to take the route of regular courts, national courts of the particular country. Model. But here it says that an arbitration can arise when there is a legal relationship, whether contractual or is not limited to simply contracts. Now, how can parties have legal relationships other than contract? And that is that trade can be done in many ways. Sometimes trade is done simply as a trade or a custom. And that trade or a custom is actually not recorded in a formal contract. Sometimes government deal with each other, and not every time the government would enter into a particular contract. Now, in today's business age, it is very hard to imagine a situation where any commercial transaction is being done without a contract. Therefore, the situations to see a particular dispute is not arising out of a contract, very frankly, are very few and very rare to see. I must admit to see, except a few cases which I know of, which are historical, I cannot imagine myself as to what are disputes that have come about which are non-contractual in nature. So the purpose of understanding this aspect is only to understand that the push towards arbitration is very large. Even if there is no contract and there is a relationship between the parties and that could be pushed for arbitration, the rule is that you must be pushed to resolve a dispute for arbitration. And why so? The common understanding of arbitration is very simple, that it is efficient in terms of time. It's going to be faster than what municipal courts can do. And it's also going to be simpler in terms of the procedure and technicalities involved in these courts. And therefore, when you look at the definition of foreign award itself, hidden in this definition is a push in favor of arbitrations. But there is a limitation. And it says that, look, you can look at a foreign award only if it is considered to be commercial under law in India. Now, what is commercial by itself is not defined, nor a very detailed paradigm has been given in the convention itself. And it has been read in very broad terms. And largely the reason why I believe it has been left in very broad terms is that we are still at an experimental stage. While I would say that we are at an advanced experimental stage on many things, and on many aspects of arbitrations, including international commercial arbitrations and foreign arbitrations, we have reached a situation of stability, but we are still very experimental about it. And in that sense, when you're looking at the framework, we are limiting it on aspects of the arbitration and the dispute being commercial in nature. Now, what does 44A mean here? And 44A is what explains the heading to part 2, that it is enforcement of certain foreign awards. Now, these awards are to be decided only when notified territories of such states are involved, which are signatories to the New York Convention. Now, more than 150 countries have signed and ratified the New York Convention, and India as a country would have notified who these countries are. And if there is an arbitration which is happening in that country and the award is coming out from that contracting country, when I say contracting, it's not a contract in terms of a trade contract or a commerce contract between two places. It is a contracting party is the signatory to the New York Convention. Only such awards will fall under the regime of the New York Convention. So to say it in other words, if in case I am looking at an award, it's a foreign award, that foreign award has been given in the territory of a country which is a signatory of the New York Convention, then such an award under Section 44 will become a foreign award in India. But say, for example, there is a country which could be a country outside the realm of the 150, 170 states, which are now the signatory of the New York Convention. Then such awards of foreign countries, of an XYZ country, which is not a signatory of the New York Convention, cannot be enforced under Part 2. Which is why when we are dealing with enforcement of foreign awards, the limitation is to those countries which are signatories to the New York Convention when we are applying Chapter 1, and signatories to the Geneva Convention when we are applying Chapter 2. So broadly, if you look at it, there are 4 things to see and examine whether the features of a foreign award have been met out. The first feature is that there must be an arbitral award, which could be foreign, which could be final or interim. And the second feature is that it must really deal with dispute between legal persons. Those persons may be bound by legal relationships, which are contractual or not. Third is that the dispute must be commercial in India. And 4, the party involved, a contracting state of where this party is situated, must be a contracting state to the New York Convention or the Geneva Convention. Now, when I say that implicit in Section 44 is the requirement that you must be pushed towards arbitration, that can be seen in Section 45 itself. 45 says, and I'll read it for you, power of judicial authority to refer parties to arbitration, notwithstanding anything contained in Part 1 or in the Code of Civil Procedure 1908, a judicial authority, when seized of an action in a matter in respect of which parties have made an agreement referred to in Section 44, shall at the request of one of the parties or any person claiming through or under him, refer the parties to arbitration, unless it prima facie finds that the said agreement is null and void, inoperative, or incapable of being performed. Now, this is a situation where if there is any aspect of a dispute which is still at large, which has still not been decided, 45 says that it says the duty of judicial authority of the state who is looking at enforcing the award is to push the favor of an arbitration, rather to say that, look, such and such action is still at large, there is nothing we can do. And therefore, 45 and 44 must be read together to see that there is a very strong push in favor of arbitrations. Now, therefore, what foreign awards are foreign awards? It is, if there is
sorry
an arbitration between...
one of the participants is asked to explain Clause A, Section 44 again.
Yes, and I'll come to that. So let me first explain this.
Sorry,
because 44A we'll get through, we'll go to the fifth, the first schedule and explain it there. But thank you so much for notifying this to me. Now, therefore, if there is an arbitration between two parties which are foreign and foreign, and the seat is outside India, that award will be a foreign award. If there is an arbitration between two parties where one party is foreign and the other party is Indian and the seat is outside, such an award will also be a foreign award. Third, if the two parties are both Indian and they have chosen to take the law outside India, such an award will also be a foreign award. Now, what has been asked in the chat is very relevant. What is 44A? Now, 44A defines is the element of foreign in this particular definition, because if you look at the definition, it says it includes an arbitral award, it includes differences which arise out of legal relationships, whether contractual or not, it must be commercial in India, and these three parameters could very well apply to domestic awards. There can be an arbitral award in a domestic award, it could arise out of legal relationships, whether contractual or not, it could be commercial. So if you will simply look at the opening paragraph of 44, it does not distinguish between a domestic award and a foreign award. That distinction actually comes in A. And how do we understand that A? I'll read it again and then I will jump to the first schedule. It says, in pursuance of an agreement in writing for arbitration to which the convention set forth in the first schedule applies. Now let's break this up. Therefore, whatever agreement that we are discussing in 44, that agreement must first be in writing. Secondly, it must be an agreement to which the convention which is set forth in the first schedule applies. Now, what is this convention that we are talking about? Let's see what is this convention in the first schedule. Now, the first schedule is the Convention on the Recognition and Enforcement of Foreign Arbitral Awards. That is the New York Convention of 1958. Now, what foreign awards are we talking here? Are awards which have been given in the territory of a foreign country. Which foreign country? A country which has signed the New York Convention, right? And how do I get that? I get that from Article 1 itself. Let us look at Article 1. It says, this convention shall apply to the recognition and enforcement of arbitral awards made in the territory of a state other than the state where the recognition and enforcement of such awards are sought. So here, say, for example, the recognition and enforcement of the award is being sought in India. The arbitral award, say, will be in the UK or would be in the USA. So I'll read Article 1 again. It says, this convention shall apply to the recognition and enforcement of arbitral awards made in the territory of a state, say UK, USA, or any other contracting state to the New York Convention, other than the state where the recognition and enforcement of such awards are sought. So the other than the state would be India. Now, reading further, and it says, and arising out of differences between persons, whether physical or legal, we have imputed and taken this in our section 44. It goes on to read, it shall also apply to arbitral awards not considered as domestic awards in the state where their recognition and enforcement are sought. Again, a broad-based inclusion. The term arbitral awards shall include not only awards made by arbitrators appointed for each case, but also those made by permanent arbitral bodies to which the parties have submitted. And we'll come to arbitral institutions in a moment. When signing, ratifying, or acceding to this convention or notifying extension under Article 10 hereof, any state may, on the basis of reciprocity, declare that it will apply the convention to the recognition and enforcement of awards made only in the territory of another contracting state. It may also declare that it will apply the convention only to differences arising out of legal relationships, whether contractual or not, which are considered as commercial under the national law of the state making such declaration. So I'll pause a moment and I will restate so that this is very clear. There is a convention, and we began our discussion today that earlier we had a convention under the Geneva Protocols in 1923 and 27. Then we came about with a more modified convention, the New York Convention. This is the convention that we are seeing here. Who are the parties to this convention? States, nation states. India is a party, US is a party, UK is a party. These nation states are parties to this convention. Each of these nation states have their own territory where they have their own municipal courts deciding on arbitrations. What are we discussing here? We are discussing that where any foreign state, like say UK or USA, if in that territory a particular arbitration has gotten decided, if we are going to enforce that arbitral award in India, then the convention gives us the power to do so. And what have we done with the convention? We have taken this convention and included in our municipal legislation, which is the Arbitration and Conciliation Act 1996 in part 2, right? Are we clear till this stage? Therefore,
Yes, sir.
So
what
I
is
have
an
one doubt.
arbitration? Yes,
Sir, I have one doubt regarding this section itself. So, under section A, section 44A, what it says is that the award has to be in pursuance of an agreement in writing for the arbitration to which the convention set forth in the first schedule applies. So my take is that it is talking about the arbitration agreement. So I'm not
that's
getting
right.
that. Do we have to mention in the agreement that this convention will apply, or Schedule A is talking about the arbitration award, but this 44A is talking about the agreement. So here I'm a little bit confused, sir.
So,
It is saying
yes.
that
So, let me explain
award.
this. Yeah, I
Okay,
have
okay.
understood your question. Imagine an umbrella, okay, a big umbrella, and then there is a small umbrella under that big umbrella, okay? Can we imagine that?
Yes, sir.
Now, the big umbrella is the New York Convention, to which countries have signed an agreement, right? Now, let us take an example of UK and India. UK and India have signed the big umbrella and say, look, we are both signatories to the New York Convention. In the New York Convention, it says that when you are a party which is signed, which are signatories, and if there is any contract to which this convention will apply, then every country in their municipal country will adopt the New York Convention. Now, the small umbrella here is the contract which two parties may sign. Now, say, for example, there is a company in London, there is a company in Delhi. They have gotten into a trade to sell medical equipment, for example. When they do a contract, in their contract, they will write that, look, we are going to resolve our contract by way of an arbitration. And our arbitration is going to be a foreign arbitration. So obviously, we are deciding that the seat is going to be outside India. Because if the seat was in India, it would become a domestic arbitration, even if a foreign party is involved. Which is what I explained. Let me recap this again. What is a foreign award? A foreign award is not an award which involves a foreign party. That's not what makes an award foreign. What makes an award foreign is that the award has been given in a territory outside India. Okay, are we clear about that?
Yes, sir.
Now, the first umbrella is the New York Convention, which India and UK have signed. The umbrella under that is the agreement which a company in London and a company in India have signed. Now, does the big umbrella apply to the small umbrella? Yes. How does it apply? It applies simply because in our law, we have included this concept of enforcement of foreign awards under the New York Convention. Am I clear, or should I explain that again?
No, okay, sir. Fine.
So maybe what I'll do is I'll make an attempt to explain it again. You see, laws, like for example, foreign laws or foreign treaties cannot be signed by independent parties, right? Such foreign treaties can only be signed by two nation states. So say, for example, if we are talking of US and India trade deal, that US and India trade deal is going to be signed between the governments of the two countries, right? What would such a treaty say? Such a treaty will say that we'll trade with each other, and when we trade with each other, what will be the currency of the transaction, how the disputes will be dealt with, what subsidies can be given. Is it that on issue of, say, for example, medical equipments, India's medical equipments will be given preference over medical equipments of other countries? So a big treaty is signed between two countries. Now, based on that treaty, now traders in both US and India can do a deal. They'll say, okay, we have a specific contract. I'm going to send you this particular medical equipment. Now, I have a contract there, right? Now, what happens when a dispute happens under that contract? Am I going to go to the US or am I going to go to India? That is going to be the issue, right? And if in case there was no paradigm of arbitration involved, we will invoke principles of private international law to decide where is this dispute going to, which court is this dispute going to go to. You will say, look, contract was maybe concluded in the US, so we'll go to the courts in US. They'll say, look, bulk of the manufacturing activity has happened in India, so cause of action is in India. Therefore, we will do this dispute in India. Now, we will be faced with a problem of a jurisdictional challenge where there is a separate paradigm of private international law to resolve that issue. Now, to cut short those issues, we have an arbitration system. Now, what will happen in such an arbitration system is that the two companies can decide that, look, if a dispute will happen, the seat will be New York, irrespective of where the cause of action has arisen or where the dispute has arisen. So a dispute happens, they say that, look, New York is the seat where this arbitration will happen. And an arbitral award is given in New York, right? Now, how do you enforce that award in India? Because that award has not been given by an Indian court, right? How does an Indian court enforce that award in India? Now, that is the mechanism which is given in part 2, that a foreign award will come to India. We will examine this foreign award. And if this foreign award qualifies, we will declare this foreign award as a decree. Once we have declared it as a decree in India, we will then enforce it like any decree in India. Like any court order in India is enforced. Any decree is enforced in India under Order 21 of CPC. This foreign award which has happened in New York, we will enforce it here. Am I more clear now? Based on what's the difference between... Yes. So when we say an agreement in writing, that agreement in writing for arbitration will be between the two companies. But to that agreement, the convention signed between the two parties will apply, which is the New York Convention, right? Now, I'll read on with the New York Convention, and you'll see a lot of what is there in the New York Convention is what we have adopted in our laws here. Now, 2, each contracting state shall recognize an agreement in writing under which parties undertake to submit to arbitration all or any differences which have arisen or which may have arisen between them in respect of defined legal relationship, whether contractual or not, concerning a subject matter capable of settlement by arbitration. The term agreement in writing shall include an arbitral clause in a contract or an arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. See, again, very liberal. It includes not only a contract, it also includes anything which could be recorded in an exchange of communication. 3rd, the court of a contracting state, when seized of an action in a matter in respect to which the parties have made an agreement within the meaning of this article, shall, at the request of one of the parties, refer the parties to arbitration unless it finds that the said agreement is null and void, inoperative, or incapable of being performed. That's section 45. Now, I'm not going to read on all the other articles, but that is something which you can do on your own. You will see that the New York Convention has been reproduced here, article by article, and you will see a lot of the material provisions of the convention have been legislatively adopted in our legislation itself, right? Therefore, now that we have some understanding of what is a foreign award, let us go and see what do we do at a transactional level. Now, when we are doing a trade, and as lawyers, we are advising a client or a company, how are we going to use our knowledge of this? Now, earlier, when parties would negotiate contracts, the important elements were price, consideration, details of the deal itself. How are you going to resolve a dispute was never really the primary consideration. But as we saw disputes have occurred and different nation states have been exercising their own sovereignty, different nation states have their own judicial systems. These judicial systems have their own problems, either in the sense that they are different or they are burdened or they are slow. We find that it is very difficult for disputes in commercial contracts to be resolved. And time and efficiency is very critical for business to go on. If in case we are aspiring to become an economy which is a $3 trillion economy or a $5 trillion economy, or for that matter, any economy of any nation state is to grow. And when contracts are therefore getting negotiated at the transactional stage, advice is being sought from lawyers as to how are we going to solve disputes when these disputes come up. And that's the challenge for lawyers to decide how are we going to draft an arbitration agreement. Now, the first thing that we must be very careful to see is the scope of the arbitration agreement. Is every part of the transaction arbitrable? And when you say every part of the transaction, how do you define every part of the transaction? Now, broadly, most arbitration agreements are drafted to say any or all differences arising between the parties including differences arising from the interpretation of this contract, shall be referred to resolution through arbitration, which is largely considered a very broad-based definition of incorporating disputes. It's an inclusive definition to say that, look, the umbrella is as wide as the sky itself, and therefore all or any dispute or difference, including differences involving the interpretation of this contract, will be taken for arbitration. And this is very critical because when we look at the Act, especially when we look at Section 48, it says that, look, there are certain defenses against enforcement of an arbitration award. And one defense there is to say that if in case the arbitrator has gone ahead and resolved a component of a dispute which he was not entitled or empowered to resolve under the agreement itself, then such an arbitral award cannot be enforced, despite a party having an award in their favor and seeking enforcement. Therefore, the first part of the arbitration agreement is very critical. It must capture all the disputes that can be foreseen, and it must be worded appropriately. The second component is language, because when we are dealing with foreign parties and international contracts, not necessarily would the language be English. If we are doing a contract with a Russian party, then there could be a dispute whether the contract is going to be in Russian or it's going to be in, for India, largely we are transacting in English. When we are doing contracts with parties like France, Russia, China, which recognize their national language as the language in which they are going to do all governmental transactions, that presents us with a big challenge. And therefore, when we are going to define arbitration agreements, it's very important to mark the language of the arbitration. And if in case, say, we are going to say that, look, the language is going to be English, it is not taken as a given. It is something which has to be negotiated and inserted in the arbitration agreement. Because if in case we are transacting and we say, look, the language of the arbitration is going to be French, then everything will happen in French, and we are limited in many ways. We will have to hire French lawyers who are fluent in French. We are going to hire a lot of translators. When we are going to give expert evidences and testimonies, they will all go in these languages. And this leads to operational difficulties of a proportion which is almost impossible to imagine at the beginning stage. Therefore, it's very important to negotiate the right language of the on which the contract will be based, or even if they say the contract is in Russian or Chinese, one can say that, look, if there is going to be an arbitration, that's not going to be in the language of the contract. That will be in a language which could be separate from the language of a contract, say English. So that is something which we can negotiate separate from the language of the contract itself. Third, if you look at UNCITRAL, it largely says that, look, you are going to be bound by the arbitrations that you are going to submit to. So if you'll see the convention itself, the convention says that, look, if in case you are going for an arbitration to which New York Convention applies, once you get an award, both parties are bound by that award. In India, legislatively, in a section, we have already included this to say that, look, once an agreement has been reached and once an arbitration has been done, that arbitration will be binding on you. But that may not be the case in another country. We may say that that's a given under the convention and that's a given under our laws, but that may not be a given under another country. Therefore, often when you read arbitration agreements, you will say that it says that both parties agree that they will be bound by the arbitral award, and the arbitral award shall be final and binding on both the parties. That element is also an important element to include in your arbitration agreement. Then, there are two aspects of procedure and the substantive law. And let me get to the procedure first. What is going to be the procedure? Now, if in case I'm going to go to Indian courts, a procedure has been set up. The Constitution says that, look, for civil courts, this is the hierarchy of courts. We have a code of civil procedure, which gives more detailed procedure as to how you're going to file a plaint, before which court are you going to file this plaint, or how are you going to file a written statement to this plaint, how a replication would be filed, how you amend a party, how are you going to amend the pleading itself, how you're going to implead a new party, remove a different party, is there a procedure for summary judgment? All of these aspects of procedure are given in your municipal law. So like in India, we have got CPC, Pakistan may have its own procedure, UK may have its own procedure, France may have its own procedure. Now, if in case we are going for ad hoc arbitrations, now what are ad hoc arbitrations? Ad hoc arbitrations are arbitrations where we do not involve an institution like the SIAC, the Singapore International Arbitration Center, or the LCIA, or there are domestic arbitral institutions in separate countries. If we are not taking these institutions, then what is going to be the procedural law? The procedural law will be the law where the arbitration is conducted. So say in case if I say that the seat of the arbitration is Paris, the law involved would be, the procedural law involved would be French law. If in case the seat of the arbitration is New Delhi, then the procedural law may come from Part 1 of the Arbitration and Conciliation Act, which says that, how will you move an arbitration? How will you choose an arbitrator? How will you amend your pleadings? How will you make a plea for costs? Those aspects are given there. So when we are looking at ad hoc arbitrations, if in case the arbitration is based in a foreign, India will apply. So these are the two branches if we are going into ad hoc arbitrations. But we have another choice, and that choice is more out of experience to say that, look, when you go to a given country, the problem is that the country may not be neutral. It may favor one party over the other simply in terms of how that law is designed. So say in case if there is an arbitration between a French party and an Indian party, and the procedural law is French, inherently that may be favorable to the French party. Similarly, if there is a contract between a French party and an Indian party and the seat of arbitration is in India, it may inherently be in favor of the Indian party. To remedy this problem, we decided that let us have some neutral procedures. And where do we find these neutral procedures? We find these neutral procedures through institutions. There are many international institutions which have been made by different institutions, like SIAC is there, LCIA is there, the AAA is there, the Hong Kong Arbitration Center is there, WIPO is there, ICDR is there, many ICSID is there. There are many centers like that which have evolved their own rules of procedure. Similarly, there are many institutions in India itself, like the Nani Palkiwala Arbitration Center, the Indian Council of Arbitration, the FICCI has a chamber for it, PhD has a chamber for it. There is the IAMC in Hyderabad, LCIA India has a chapter here. So there are many institutions in India also where you will go. Now, very quickly, let me give you a visual understanding of what these procedures look like. So let me show SIAC, which is more popular in India because it's closer from India. And the advantage of going for these procedures is also that these procedures are absolutely specific to arbitrations. And therefore, in that sense, they are again not broad-based like procedures of municipal countries. So if you look at SIAC's rules, it gives procedure on scope of application and interpretation, notice of arbitration. Let us see notice of arbitration as an example. Now, 3.1 says, a party wishing to commence an arbitration under these rules shall file with the registrar a notice of arbitration, which shall include reference to the arbitration agreement invoked or a copy of the arbitration agreement, a reference to the contract, and such and such. It gives a detailed procedure with which notice for invocation of arbitration will go. Then look at 5. For example, in India, we have a system of a summary procedure. Now, there is an expedited procedure mentioned here that if in case disputes of a particular value, if in case there is an exceptional urgency, then there is an expedited procedure given in SIAC. And that's what you'll find in most arbitral institutions. LCIA has something similar. Then let us quickly go to seat of arbitration. 21. Now, seat of arbitration here says the parties may agree on the seat of the arbitration. Failing such an agreement, the seat of the arbitration shall be determined by the tribunal, having regard to all circumstances of the case. The tribunal may hold meetings, hearings, and meetings by any means it considers appropriate, and at any location it considers convenient or appropriate. And I'll come to seat of arbitration more extensively after this. Language of the arbitration, what we were discussing earlier, it says, unless otherwise agreed by the parties, the tribunal shall determine the language to be used in the arbitration. If a party submits a document written in a language other than the language of the arbitration, the tribunal, or if the tribunal has not been constituted, the registrar may order that party to submit a translation in a form to be determined by the tribunal or the registrar. And you see, detailed procedures have been given for hearing, for witnesses, tribunal-appointed experts, additional powers of the tribunal, jurisdiction, interim and emergency relief, how will the award be written, correction of awards, fees and disputes, costs of the arbitration. Similarly, if I'll show you the rules of LCIA, which are similar. So one is request for arbitration. 16, 17 is language. We discussed language. So let us look at language. Language in LCIA is more elaborately explained than SIAC. It says the initial language of the arbitration until the formation of the arbitral tribunal shall be language or prevailing language of the arbitration agreement, unless agreed in writing otherwise. See, well, that's what I was saying. Very important to negotiate what language do you want and should be included in the arbitration agreement itself. In the event that the arbitration agreement is written in more than one language of equal standing, the LCIA court may, unless the arbitration agreement provides that the arbitration proceedings shall be conducted from the outset in more than one language, determine which of those languages shall be the initial language of the arbitration. A non-participating or defaulting party shall have no cause for complaint if communications to and from the LCIA court and registrar are conducted in the initial languages of the arbitration or the arbitral seat. Following the formation of the arbitral tribunal, unless the parties have agreed upon the language or languages of the arbitration, the arbitral tribunal shall decide upon the languages of the arbitration after giving the parties a reasonable opportunity to make written comments and taking into action the initial language of the arbitration and any other matter it may consider appropriate in the circumstances. Last, if any document is expressed in a language other than the language of the arbitration and no translation of such document is submitted by the party relying upon the document, the arbitral tribunal may order, or if the arbitral tribunal has not been formed, the registrar may request that the parties to submit a translation of all or any part of that document in any languages of the arbitration or of the arbitral seat. Therefore, when we are going to look at procedure, ad hoc procedure would be procedure of the municipal country where the arbitration is happening. But we can adopt a more focused, dedicated, and refined procedure from one of these institutions, SIAC or LCI or any of the other institutions. And therefore, if there is any procedural requirement, how am I going to invoke the notice of my arbitration? What's going to be the language of the arbitration? How am I going to appoint the arbitrators? What's the procedure which the arbitrators are going to follow? How interim awards are to come? All of this are now embedded in the procedures given by these institutions itself. Now, the arbitration agreement must not only define procedural law, but must also define the substantive law. Now, we've been constantly talking about seat of arbitration. Now, in many ways, governing law and seat of arbitration could be the same. To say that if in case I say that the seat of arbitration is New Delhi, the laws of India would apply. What laws would apply in India? Rules of evidence could apply here. The Indian Contract Act could apply here. The specific legislation which could be applicable to the transaction, which is an Indian legislation, those legislations would apply here. Therefore, it's very important that when we are drafting arbitration agreements, it is critical, it is fundamental for us to define the seat of the arbitration, for that is the governing law. A governing law can be based in any country, and that becomes a subject of negotiation depending on what kind of parties are involved. Say, in case there is a party which is an American party and an Indian party, money is to be paid to the Indian party. The Indian party is supposed to perform the contract in terms of selling the goods or service. The party which is releasing the money tends to have the upper hand in the negotiation. And that party will say, no, we are not going to agree to the seat of arbitration to be in India, even though we've agreed that the procedure will be, say, LCIA, so Indian procedures are not involved or American procedures are not involved. For determination of the rights and the liabilities, the law of USA will apply, or the law of UK will apply. Say to say that we'll take the law of a neutral country. And this is very critical in negotiating arbitration agreements. Every country obviously wants that the arbitration agreement should be done in the laws of their country because they have a familiarity. Or sometimes countries whose laws are not very developed. So say if you look at certain Middle Eastern countries, or if you look at certain African countries who recognize that their laws are not developed enough, and they'll say that, look, laws in the UK or in the US are very developed. Sometimes they simply choose that, fine, we agree that the seat of arbitration may be based in London or it may be based in the US, where the laws are better defined. Sometimes this also involves a concept of costs, because if I am a party in Africa or in the Middle East or even in India, and I am going to arbitrate where the governing law is the laws of the US and the UK, I will have to hire lawyers in the UK and US to fight my case. And maybe the costs of such arbitration may be very heavy. And sometimes if we are dealing with contracts which are not of very high value, we could negotiate and say, look, it's fundamental. If in case we are going for a dispute, it has to be laws of India, or it has to be laws of a smaller country. So what is the governing law in an arbitration agreement is not defined in terms of legalism so much, negotiation. It is very common practice that many countries submit to the laws of the UK because the systems in UK is better developed, the jurisprudence is more stable, the judiciary has been dishing out judgments which are based on precedent, and those precedents have been consistently ironed out, unlike India, where we are still at a developmental stage where precedent is very sporadic, where one judge's judgment is changing another judgment and legislation is changing that judgment. That's happening a lot in the field of arbitration. So many times parties who are in different countries may say, look, the seat of arbitration may be London. The governing law may be London. And therefore, when we are doing arbitration, there are no restrictions like that. Two parties can consent and choose their procedure to resolve the dispute. Their dispute will get resolved, right? Now that we are clear on what are foreign arbitrations and foreign arbitral awards, we are clear that at the transactional stage, how are we going to draft agreements, foreign arbitration agreements? What are the components that we are looking there? We are looking at the scope of the dispute that is covered in the arbitration agreement. We are looking at the governing law. We are looking at the procedure. We are looking at language. We are looking at the binding value of the arbitration. We may also examine how many arbitrators we want to choose. So, for example, in Indian law, when we are drafting a domestic arbitration clause, we have a choice to either say that it will be a one-member tribunal or a three-member tribunal. And in the section 11, we've given a specific procedure that if parties cannot agree on their arbitrators, then there is a particular procedure which finally ends up in the court, and then the court appoints a tribunal, a judge. Either it can be an ad hoc judge who's appointed, or Indian courts can push you towards an institution. And that can be in IAMC in Hyderabad, or it can be different institutions which are not state level, but they are national. In fact, DIAC, there are many foreign international arbitrations also which are being submitted to DIAC, much like it can be submitted to the SIAC or LCIA. Now, how do you choose which governing country? I've already covered that. That's not so much etched in legalism, but etched in practicality and the negotiating power of these parties. Now, let us come to a concept of enforcement of the award, part 2. What does the section say? All right, we drafted an agreement. There was a dispute. The parties invoked the arbitration. The language was all set. The procedure was set. Whether we took SIAC, LCIA, we took ad hoc, whatever system of procedure and governing law we took, the arbitration went ahead. Now an arbitration award has been given. This arbitration award is a foreign award because it has been territorially given outside India. Now, we want to enforce this award in India. How do we enforce this award? Therefore, the last part of our class is on this aspect. Now, it will be very difficult to enforce awards. Now, CPC itself has a system which says that, look, we will enforce foreign judgments. But because arbitration is supposed to be specialized and it's supposed to be more time efficient, The Arbitration and Conciliation Act has a separate part, Part 2, which is dealing with enforcement of certain foreign awards. And how are these awards enforced? Now, these awards can be enforced in two ways. Either you enforce these awards under the New York Convention, which are sections 44 onwards, or the Geneva Convention, which is section 53 onwards. Geneva Convention is an earlier convention, and therefore, in practice, we don't see many foreign awards which are based on the Geneva Convention. But if you will see, barring a few differences, the New York Convention and the Geneva Convention in terms of enforcement in our legislation are pretty similar. So I'll focus on the New York Convention today. But before I start with New York Convention, what is one major difference between the Geneva Convention and the New York Convention? The New York Convention is entirely based on consent. And therefore, if, say, a party is not a signatory to the New York Convention, if it's not a contracting party, we have seen in 44A that foreign award cannot be enforced under the New York Convention. But Geneva Convention did not follow a concept of consent. It said that if there are two
So your voice is not clear.
that aggressor party is not will. Geneva Convention was not simply to resolve maritime issues, more complex issues, and it was a reaction to the First World. Please go ahead. I believe somebody was asking something.
Yes, so your voice was lagging for a while.
What was the part where the voice started cracking? So I'll just quickly do a summary of those parts.
You had just started explaining the Geneva Convention, the difference.
Can you say that a little loudly, please?
The difference between the New York Convention and the
Yes.
Geneva Convention, and you had just begun the Geneva Convention.
Right. So
Yes.
I'll just quickly recap that. Largely, the difference between the Geneva Convention and the New York Convention is one of consent. In the New York Convention, which is entirely based on consent, the Geneva Convention was not entirely based on consent. And that is because the background of the Geneva Convention was the First World War. After the First World War, we saw that, look, disputes have to be pushed to be resolved between nation states. Therefore, they said that, look, if a nation state said, look, I'm not submitting to Geneva Convention, I'm not coming to resolve the dispute, they would say that by deeming fiction, we will declare you as the aggressor state, that you don't want to resolve this particular issue. The New York Convention is a refinement in that sense. And when we look at New York Convention, the way it has been included in Part 2, we have limited it to the concept of it only including commercial aspects, right? So that's broadly the difference between Geneva Convention and New York Convention. But in real time now, very rarely would you see any contract which would be under the Geneva Convention. We are largely dealing with the New York Convention. So I'll begin with section 52 first. 52 says, chapter 2, which is the chapter on Geneva Convention, it says, chapter 2 of this part shall not apply in relation to foreign awards to which this chapter applies. Therefore, New York Convention has an overriding effect. Wherever the chapter on New York Convention applies, the chapter 2 does not apply. So we've excluded that. Let's look at 51. 51 is a savings clause. It says, nothing in this chapter shall prejudice any rights which any person would have had of enforcing in India of any award or of availing himself in India of any award if this chapter had not been enacted. What is the purport of 51? The purport of 51 is this word, certain. 51 says that, look, if this chapter had not been written, and if anybody had any remedy of enforcing a foreign award in India, that particular remedy survives. So therefore, part 2, the implication is not that only a foreign award under the New York Convention can be enforced in India. And any foreign award which is not under the New York Convention or the Geneva Convention, I'm sorry, we are not enforcing this in India. That is not the situation. The situation is that other than the New York Convention and the Geneva Convention, if there was any other remedy you have, section 51, the savings clause, allows you to use that remedy. So in that sense, enforcement of foreign awards in India is more broad-based. Now, we have looked at 44 and 45. 46 is when foreign award binding. We've already seen this in the convention, so I'm not explaining this again. It simply says that, look, when you're getting into foreign awards, if it is enforceable, it must be considered binding. You cannot then wriggle out of it. Now, if I have to move an application for enforcement of a foreign award in India, 47 provides the necessary requirement. So essentially, if a foreign award has to be enforced in India, it's a two-stage process. There will be a foreign award. We will make an application to the Indian court and say, look, this is a foreign award. Examine whether this foreign award qualifies to be declared a decree. The Indian court will examine it and it will come to one of two conclusions. If it comes to the conclusion that yes, this qualifies to be a decree, it will declare it to be a decree. And once it becomes a decree, you can file enforcement proceedings under Order 21 of CPC, like you will file enforcement proceedings for any decree in India. Or it could look at the foreign award and say, I'm sorry, this foreign award cannot be enforced in India. These are the only two situations. Therefore, enforcement of a foreign award in India is a two-stage process. The first stage, does this foreign award qualify to be a decree? Stage one has been yes, stage one has been satisfied. And therefore, stage two, which is under Order 21, enforcement of the decree like any decree in India. What happens when you say a no? And why would you say a no to enforcement of an arbitral award? So let us look at 47 first. When I'm applying to an Indian court, what should my application contain? My application should contain three things. The heading here is evidence, but what are the three things that they expect you to file? They expect you to file an original copy of the award. Very basic. If in case I'm seeking enforcement of a foreign award, obviously, I will have to give the original award or a duly authenticated copy. Two, I must give the original arbitration agreement or a duly certified copy, very similar to what we already have in part one. And thirdly, it gives us a liberty to lead evidence to prove that the award is a foreign award. And we discussed it in the beginning. What makes an award a foreign award? Territoriality. And therefore, if in case there is any dispute on the first two aspects, C gives us a liberal provision to lead evidence for the same. 47.2 simply says that, look, if it's in a foreign language, then you must give a translated copy, and that translated copy must be authenticated. What is the authentication? It's there, I'm not emphasizing. 48 is the most critical section here. Because if I am a party against whom an award is being enforced, then I will go to court and say, look, I am challenging this application for enforcement. This award should not be enforced against me. In other words, it should not be made into a decree in India. And on what basis can I make that argument? That argument is given in subsections A to E, and then the explanation. What it essentially means, I'm not going through them one by one, but what it essentially means, if there is something fundamentally wrong in the arbitration agreement, if the foreign award has given a determination on points E and F, and that point E and F could not have been arbitrated under the original agreement, then I'm sorry, you can't enforce that award in India. If there is any problem with the constitution of the tribunal itself, then I'm sorry, you cannot enforce that in India. If there is any difficulty with the arbitral award in the foreign country where that award has been given, which so renders it inoperative, I'm sorry, you cannot turn a blind eye and enforce that in India. Now, earlier, public policy was also an issue. And if you recollect, section 34 has an element of public policy. It says that, look, in domestic arbitrations, if in case we want to challenge a domestic arbitration, section 34 allows so. And one of the provisions there is public policy. If in case the award is contrary to public policy, you can challenge it. And therefore, there was a conversation whether that includes, that part one is included in part two. Balco said no, part one and part two are different. The 2015 Amendment Act has given a proviso to section 2.2 of the Arbitration Act, which we'll see in a while, which says, I'm sorry, no, it can't be mutually exclusive. Some parts, and that is largely where Indian courts can intervene in an arbitration on fundamental issues. Sorry, you can't exclude Indian courts completely. And therefore, part one will apply to part two in those specific situations. And the 2015 amendment in that sense has overruled Balco. Now, let us look at 2.2, therefore. Section 2.2, I'll just scroll it. This part shall apply where the place of arbitration is in India. And the whole discussion in Balco was that will it include foreign arbitrations? And they said, look, it very clearly says territoriality of India. And therefore, when you're looking at part 2 and part 1, they are exclusive. And therefore, both of them cannot be intermingled. But the proviso here, which has come by way of a legislative amendment, has overruled Balco. It says, provided that, subject to an agreement to the contrary, the provisions of Section 9, which is going to court asking for interim measures in arbitration agreements, 27, which deals with assistance that a tribunal can take from Indian courts, and Clause A of subsection 1 and subsection 3 of Section 37, the limited cases where you can appeal from an award, shall also apply to international commercial arbitration, even if the place of arbitration is outside India, and an arbitral award made or to be made in such place is enforceable and recognized under the provisions of Part 2 of this Act. And therefore, in summary, that is what it is. Bhatia International said something. Balco reconsidered Bhatia International and said, look, Part 1 and Part 2 are mutually exclusive. Everything is based on territoriality. Therefore, Part 1 and Part 2 do not intermingle. The 2015 amendment, by the inclusion of this proviso, has overruled Balco to say that in these limited situations, you cannot say that the Indian courts in Part 1, in terms of these 3 sections, will be held helpless and they cannot intervene. And this is largely done to remedy a situation where if an Indian party is involved and this is being examined by an arbitral tribunal outside India, or that award is being examined outside India in a foreign country, the Indian party can dissipate its assets in India such that no enforcement would be possible. And therefore, to get protective measures, you cannot leave a party remediless. And that is the reason why this proviso has been inserted to remedy that wrong. Now, another issue was the decision of Venture Global, which said, look, public policy is a wide requirement. And if in case a particular foreign award is contrary to the public policy of India, then sorry, we can't enforce it in India. And that led to many different conversations, because what is public policy in India may not be a public policy in another nation state. And that led to many digressions and differences. This again has been resolved by way of a legislative amendment. And Venture Global has been clarified to say that, look, public policy, when it comes to Part 2, is now limited to certain things. These limitations are very specific. You see the explanation 1. It says, for the avoidance of any dispute, it is clarified that an award is in conflict with the public policy in India only if 1. The making of the award was induced or affected by fraud or corruption, or was in violation of Section 75 or Section 81. 2. It is in contravention with the fundamental policy of Indian law. 3. It is in conflict with the most basic notion of morality of justice. Explanation to this: for the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. This ensures finality to arbitral awards. If in case a party says, look, you cannot enforce this arbitral award against me, and his defense is one of public morality, his defense on public morality can survive only basis explanation 1 and 2 here. And in that sense, what is public policy here is in a narrower sense to what is public policy in 34. In fact, through amendments now, 34 by the challenge through 34 by itself has been further narrowed down. And more the approach, the judicial approach in India has been that, look, the courts are going to keep their hands off arbitrations. The whole concept of arbitration is that it must be free of delay and it must be free of complicated procedure. And therefore, we, the courts who are dealing with delay and complicated procedure, will stay away from arbitrations as much as we can, whether it's domestic arbitrations and more so when we are dealing with foreign awards. I will conclude with an aspect of limitation, because what is the limitation to apply for an enforcement of an arbitral award in India. There are three different limitations. If in case the foreign award deals with a mandatory injunction, then the limitation is 3 years. If in case we are dealing with a perpetual injunction, then there is no limitation whatsoever. And if we are looking at any other decree other than these two, mandatory injunction and perpetual injunction, then the limitation is 12 years. Now, to recap the conversation we had today, we learned to identify what is a foreign award, which is largely based on territoriality. Foreign awards are largely coming from two conventions. We are majorly discussing the New York Convention, which is based on territoriality and as a set of conventions, a lot of which has been included legislatively in our legislation. Then we discussed about drafting of arbitration agreements. Arbitration agreements must have certain essential conditions in terms of the encompassing of the dispute, the language, the bindingness, the procedural law, the substantive law. We discussed how enforcement of these arbitration awards happen in India and the great push in favor of arbitration and the courts taking an approach where they don't want to interfere with foreign arbitration awards as much as they can. What is the method of applying for an enforcement of an arbitration award in India in terms of the requirements in 47? What all should the petition contain? And secondly, what are the defenses one can take under 48 to oppose an enforcement? Once a party succeeds and the court says that, all right, you qualify the conditions, the objections under 48 are not met, 49 triggers, 49 says, when the court is satisfied that the foreign award is enforceable under this chapter, the award shall be deemed to be a decree of that court. Now, once this has happened, we are a country which is very trigger-friendly to appeals. We are in a situation where our Supreme Court is not like the Supreme Court of, say, the US. Our Supreme Court in many ways has become a right of appeal. And therefore, we go through many rounds of appeal. And many rounds of appeal again defeats the purpose of arbitration in the sense that the dispute gets elongated and the finality of the dispute is not reached. But appeal is also a fundamental provision which comes from the Indian Constitution. Therefore, the balance has been incorporated in Section 50. What is the balance? The balance is, notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the order refusing to. So you see how limited this is. Only if there is a refusal to refer the parties to arbitration under Section 45. If you remember, I said in 45, it is the duty of states to push parties to resolve things through arbitration. And if in case, say, the courts have refused to nudge parties to arbitration, you can go up in appeal. Secondly, enforce a foreign award under Section 48. So if, say, a party has filed for enforcement of a foreign award, another party has filed a challenge under Section 48 saying, sorry, this cannot be enforced against me, and the court decides, all right, I decide in favor of the objector that this contract cannot be enforced, then in that situation, you have a right of appeal, but not the other way around. If in case I seek an enforcement and I'm granted an enforcement and my award is converted into a decree, then the objecting party cannot appeal in India. That goes both for 45 and 48. But it broadens its scope in 2, and it says, no second appeal shall lie from an order passed in appeal under this section, but nothing in this section shall affect or take away any right to appeal to the Supreme Court. Therefore, the constitutional powers of the Supreme Court have not been curtailed, cannot be curtailed is my point, but it has, and for that reason, it specifically says that any right to appeal to the Supreme Court is open to you, right? Now, if there are any questions, I'll be very happy to take any questions.
So I would like to ask, the line you said after saying that our country is very trigger friendly to appeals about Supreme Court. I missed that line. Can you repeat that?
If you look at our hierarchy, court hierarchy, under our CPC, a suit must be filed in the lowest court possible. And the limitations are one of territoriality. Action is in Madhya Pradesh, you will file it in Madhya Pradesh. Within Madhya Pradesh, if it's in a particular city, you will file it in that particular city. Similarly, several courts in India have a pecuniary limit. For example, in Delhi, anything below 2 crores go to the district courts in Delhi. Anything above 2 crores, even if it's an original litigation, goes to the Delhi High Court. Now, once any court in India gives a decision, there are multiple levels of appeal. So a normal suit, there's a first appeal and a second appeal, which is given in the CPC itself, section 96 and section 100. Or even if we are looking at specific statutes where tribunals have been created, for example, the Consumer Protection Act, based on territoriality and pecuniary jurisdiction. Again, a case may be filed before a district consumer dispute redressal commission, then an appeal will go to the state commission, then an appeal will go to the national commission, then an appeal will go to the Supreme Court. And this is asides the fact that Supreme Court has a power under section 136 to deal with an appeal from any order, from any court or any administrative body in India. So if you look at our constitutional system, it is trigger friendly for appeals because we are a diverse country, territorially, society-wise, language-wise. Our constitution is a constitution which recognizes the right of a party to appeal a decision. Now, I am not speaking of the malaise that has come about, that appeals are in the routine and the matters have been delayed. So I'm not getting into that conversation. And simply saying that the way our system is, there are as it is number of appeals. And when we look at section 50, it is a balance. While it does not take away your right of appeal, but it legislatively limits it and yet does not interfere with the Supreme Court's broad powers. Would there be any other question?
Yes, sir. Sir, so the term appeal here also means SLP. I mean, SLP is an
Yes.
original
Yes.
jurisdiction. I mean, so
It's
the
not
word
an
appeal
original
means-
jurisdiction. Yeah. See, what is SLP? SLP means that the Supreme Court, if it deems fit, can and any order of any administrative body or court in India can directly be appealed to the Supreme Court. And if the Supreme Court so deems fit, it can exercise its powers under 135 and 136 and deal with it. So in that sense, it's not an original jurisdiction. It is a first appeal like that.
Okay. Right, sir.
And that has been a criticism of the Supreme Court. It says that we have Supreme Court is very happily entertaining 136, but maybe the founders give cases where an appeal should directly come to the Supreme Court. But it has been seen in practice that Supreme Court has more readily accepted more and more appeals.
Okay, sir. Okay. And sir, the party winning the foreign award, that same award the party can enforce in multiple jurisdictions at the same time?
That's a very good question. And no, but you see, why would the party want to enforce? If you look at it logically, see, legally, yes, what you're saying is right. But logically, why would anybody come to enforce an award in India? They would come to enforce this award in India only because the asset is in India, either of a foreign party or of an Indian party. That's the reason why they want a decree in the Indian court, right? So say in case an asset is in India, why would they seek enforcement against that asset in another country? Therefore, the multiplicity of enforcement in different countries may not be an issue. But in cases where assets of a company spread out, say, for example, an issue came out with the Sahara case, where they said, look, you had hotels in the US, and to recover money, can you enforce this in courts in New York? Why not? If that is such as the situation, then of course, enforcement can be sought at multiple places. But of course, within the limitation that all of them must be signatories to the New York Convention.
Okay, sir. So, I mean, I don't, just from the practicality point of view, I mean, will the party who's enforcing this award, will they have an advantage? I mean, they are, say, a company against whom they are enforcing is MNC and they have assets in different.
They should have an advantage because they have they've gone through a legal process of obtaining an award in their favor. Therefore, when you'll go through 48, there are only very fundamental reasons on which you can object. And it clearly says you can't object on merits. if in case there is something foundationally wrong, that, the tribunal went ahead and adjudicated something which it was not entitled to do, there was a problem in the constitution of the tribunal itself, unless the problems were not foundational, an Indian court, while enforcing a foreign award, is not going to apply its mind on the merits. And therefore, legally, jurisprudentially, yes, the party who is seeking an enforcement must have an upper hand.
Okay, so suppose if both the jurisdictions allow the award, and that award, the sum total of award goes way more above the or any compensation which the assets will be converted into money. So in that case, of course, the second party will then say that the money is being recovered from from the assets of the first jurisdiction. So we say that don't. This thing.
That is right, and I'm sure that such an argument will be very tenable even in these proceedings. If in case, say, here a party is supposed to recover 100 crores, say for example, and he has already recovered 90 crores in another jurisdiction, that is a very relevant defense that another party can take and say that, look, in these enforcement proceedings, he cannot be entitled to more than 10 crores because 90 he has already recovered. So in that sense, the award cannot be enforced beyond that. That is a very legitimate argument which can be raised.
Okay, sir. And sir, can you explain, what is the meaning of fundamental policy of Indian law? Some case laws which deals with it, or just in a nutshell.
So it is difficult to, say that in a word, because there are certain different judgments which have tried to underline this. It is very difficult because there can be no formulaic explanation of what is fundamental. In many ways, you can recognize on a case-to-case situation as to what will be fundamental. Now, for example, what could be fundamental? Maybe here, when we are looking at money which has come from proceeds of crime, ordinarily you say that, look, a person who's accused is not, the burden of proof is not on that person. In India, the burden of proof is on the state to prove that the accused is guilty. But when you are dealing with specific crimes like these, money laundering crimes or crimes which have originated out of heinous crimes, they say, look, now it's on the accused to show that it is not so. And another country may say, look, that's not how it is here. But you can make an argument to say that, look, this is fundamental policy of India. It's fundamental to Indian law. And such an argument, though may be different from the understanding of some other jurisdiction, could be enforceable in India for these reasons. So it's just an example that I'm giving you. A couple of times the courts have examined this, but my answer in one line is to say that there is no formulaic definition of doing it. It depends on case to case. It depends on the gravity of the situation. It depends on the kind of law that is under conversation.
Okay, sir. And so, lastly, sir, there's one, Section 34 is a bit broader. It also includes the term patent illegality. So can you just throw some light? What is the difference between fundamental policy and patent illegality as per Section 34?
Yes. Patent illegality would be something which we don't consider legal at all in India. Now, for example, in the US jurisdiction, you are entitled to get damages which need not be on actuals. In India, we do not have damages which are beyond actuals. So say a case, if somebody spills hot coffee on themselves in the US, you can actually say that, look, my damage is so many multi-million dollars. You can get an award, you can get an enforcement in their law. In India, they'll say, okay, you spilled a coffee on yourself. That led to what injury? Okay, the injury was you had to go through surgery. What was the cost of the surgery? Or reconstructive surgery? What was your mental agony? And therefore, actuals basis, we will quantify the damages payable to you. Now, see, this way is, if in case you are asking something which is fundamentally not there in Indian law, that won't be covered under this at all, right? So if in case there is a domestic award in India which grants you damages which are not on actuals, that will not survive a 34 challenge then.
Okay, sir. Okay. Thank you, sir.
But good questions, very good questions. Right. So there are no other questions. Thank you so much for joining me today. more particularly so that I
Thank you so
understand that it is at the cost of watching the cricket match. I hope the score is much better than what it was when I started the class. And thank you so much for participating in the class. It was my pleasure. Thank you.
Thank
Thank
you,
you,
sir.
sir.